In 1985, the U.S. Supreme Court, in the case of Tennessee versus Gardner, said that a police officer could not shoot a fleeing felon. But also in that case, the Supreme Court said that a police officer could elevate force to that degree that he or she believed was reasonable to stop the force that he or she perceived was happening to protect himself or the community. I've been practicing law for 18 years, and we call that standard arbitrary and capricious, subjective. We've had a debate for a whole year over the issue of police brutality. And we see time and time again, individuals are charged, no conviction. Individuals are arrested, but they're not charged, no conviction. At the National Bar Association, we say there are many solutions to this problem, but one that must be addressed, that sometimes is being ignored, is that the law is flawed. And until we change the law, you can arrest as many cops as you like. But if they go before a jury that has to second guess and apply their thoughts for what an officer was doing, they're going to at all times believe the officer. We ain't asking for much. All we're asking is that you treat minority communities fairly. We don't have a war. And get me clear, quote me right. We don't have a war against police officers. I want them to police my community. We have a war against bad police officers. We don't want them to paint, I don't want my members to paint police officers with one brush, just like I don't want police officers to paint my community with one brush. It should not be right to police every African American the same way, if it ain't right for me to paint every police officer the same way. Justice requires that you judge me based on the character of who I am and not the color of my skin. So we're saying, if you want to change, so we came here today saying, McKinney's not a moment. This is a movement. And if America don't stand up and take notice and begin to change the laws on a state, a local, and a federal level, we'll be back here again. Thank you.